This was a pre-existing obligation. How was it created? Chapter 78 didn't create $87 billion.
Call it what you may, you are still arguing for this law to require every legislature for, I don't even know how long out, because there doesn't seem to be an end to it, to put in a certain specified amount to be determined, but we have an idea of what it is, into the budget every single year forward. If that's not a long-term binding obligation, coupled with the language that was used in the statute, I don't know what is.
I agree with you. It is a long-term binding obligation. It absolutely is.
And isn't that exactly what is interdicted by the debt limitation clause without voter approval in an amount of this size? Because it surely exceeds 1% of the budget.
I don't think so. I don't think it is.
Explain why.
And the reason I don't think it is because the debt limitations clause and its history, going back to the early 1830s, was designed by the framers for a very explicit purpose. Judge Jacobson understood and recognized this. Right? At that point in time, right, states were going out and borrowing huge amounts of money with interest in order to finance capital projects, and then as a result of a financial crisis, they were defaulting on those debts. And the framers of the Constitution wanted to prevent the state from irresponsibly going out and borrowing those sums of money without voter approval.
The language goes well past borrowing. The language of the debt limitation clause goes well past borrowing. How do you explain that?
Well, I think the debt limitations clause clearly was designed, I think, by the framers to address borrowing, but most importantly, right, it was at least designed, and I think the cases of this court recognize this, for situations where you're actually creating a debt, not where you're figuring out how to pay off an obligation. Every time the state...
Even leases are subject to appropriation. Even leases under the building authority case require just essentially an indication that most likely the appropriation would be in the Appropriation Act from year to year. That's how the building authority case was ultimately approved in Emirata, was it not?
Yes, it was. But here, I think the question for the court that the court grapples with is, does the legislature and does the executive, in their sovereign capacities, have the ability to recognize that there is an outstanding obligation, that there are ordinary expenses of government that have to be paid, and under Lance v. McGreevy, cannot be paid by going out and borrowing money. You can't pay for the ordinary expenses of government by taking out a loan, as per this court's decision back in 2004.
Let me ask you the question I asked Mr. Riley. Do you think Lance then only stands for the proposition that you can't borrow for the current operating expenses, or do you think it signals direction from this court that you can't engage in long-term financial obligations for operating expenses?
I think what Lance stands for is the principle that you have to have a balanced budget. And as per the Appropriations Clause, that the Appropriations Clause means something. And what that means is that each year you have to have sufficient revenue to meet your operating expenses. And operating expenses include deferred compensation, which is in the form of a pension benefit. They concede, by the way, and it does seem to me that this is a somewhat anomalous situation, they concede, the state, right, that if you are an employee of the city of Trenton, you have a contractual right to have your employer make its annual required contribution. But if you are a teacher in the city of Trenton, working for the Trenton Board of Education, you don't have that equivalent right. Why? Because the money has to be paid by the state. But the fact of the matter is, all that state is doing, all the city is doing, is paying your deferred compensation. You are owed that deferred compensation. Is it really possible that the sovereign authority and power of the legislative branch of government and the executive branch of government can't make a decision that they are going to, in fact, have balanced budgets, that they are going to respect the integrity of the Appropriations Clause, that they are not going to allow every single year the state to create a debt or an obligation because they don't pay their normal contribution, an ordinary operating expense, deferred compensation, every single year they don't pay it, the state, not Chapter 78, the state of New Jersey creates an obligation that has to be paid in the future. And finally, after years and years and years where these pension funds are about to go bankrupt, the legislature and the governor come together and say, you know what, we're going to impose upon ourselves some fiscal discipline, because at the end of the day, not only will we pay the bonds that are voter approved, but we're going to pay the bonds that are not voter approved, that are subject to appropriation, before we pay for the deferred compensation in the form of pension benefits for the employees who work for the state of New Jersey. Have to deal with that one day or another. It may be sooner or later.
Tell us the impact of your position on future legislatures. Can a legislature ever amend Chapter 78 in a way that might reduce the obligations that are being paid without running afoul of the contracts clause?
I think the legislature has a variety of different options.
For current employees? Go ahead.
Right. Well, first of all,
not perspective, to change the scene right now in an effort to address the pension problem.
Look, they have the ability, as they did in Chapter 78, right, to say we're going to change requirements in terms of when you can retire for people who do not have a non-forfeitable right to their benefits. Everybody hired since 2010 or even before that falls into that category. I mean, there are any number of ways, right, that the legislature can deal with this problem. Ms. Riley says they can increase employee contributions. If she's right about that, independent, right, of the state paying its money, right? At this point, almost all of the pension payments that are being made by employees are going to fund this pension system.
Is it your position that the seventh payments cannot be changed by another legislature?
Chapter 78 says that. It creates a contractual obligation to adhere to that, and if you have a contractual obligation to make those payments that is constitutionally protected, then yes.
So
U.S. Trust says you cannot then later change that contractual obligation.
So fiscal year 2018 arrives. A $5 billion payment is due. And notwithstanding best efforts all around, the state is in a difficult situation. Can the legislature and the governor together restructure and come up with a different plan that reduces that $5 billion payment?
I think if it's reasonable and necessary is the answer. And I will say this, and Spina did recognize this. Every court, right, virtually every Supreme Court, right, state Supreme Court, that has recognized a constitutional right not only to the pension benefit but to a properly and securely funded pension system has also recognized that the legislature and the governor have the right to restructure that system in a way that will ultimately ensure its fiscal soundness and result in employees receiving the benefit to which they are entitled. And so I do think, and I think this is critical, right, that a contract clause analysis builds into it that kind of flexibility and discretion that the sovereign powers get to exercise when they do this. And they can do it in the future too, right? So is it immutable? It's not immutable if your scenario, Justice Rabner, were to come to pass. $5 million is due, the money isn't there. We can't pay it, we have to deal with this in some way. Under those circumstances, yes. But what this
So you're arguing that this is a very unique form of statute that cannot be changed by the legislature unless the legislature and governor can demonstrate a reasonable and necessary reason for altering the formula that it passed in Chapter 78.
Well, I am making that argument, Your Honor, and I will say that, yes, it's unique, but again, I come back to the fact that if you can create a non-forfeitable contractual right to the benefit, if you can impose upon local governments the contractual obligation, constitutionally protected, to pay the annual required contribution, if you can create those contractually binding rights, which are binding on future legislatures, yes, I believe that the legislature and the governor could, in the form of Chapter 78, do precisely what they intended to do and do exactly what they said that they were doing, which is they were going to pay these monies into the pension system because they understood that those monies were owed. They didn't create that debt. There's simply a payment plan to make sure that it's paid off and that people get pension benefits to which they're contractually entitled.
But there can be an impairment so long as it's reasonable and necessary to serve an important public purpose.
And that's true. And that's exactly the basis upon which the OLS opinion, right, and that issue was asked. Of course, OLS issued an opinion here on Chapter 78, found that this was a constitutional provision and should be found as such.